Yeah.
This is the second session of the international webinar, Free Speech, Democracy and Rights of Minorities. Today, the session is called Democracy, Hate Speech and Misinformation. Today, the speakers will be Helen Norton from University of Colorado Law School, Filimon Peonidis from Aristotle University of Thessaloniki, Migle Laukyte from Universitat Pompeu Fabra, and Irene Spigno from the Interamerican Academy of Human Rights. The session will be divided in the presentations of the speakers, and the second part will be a general debate with the intervention of the discussant, Alexander Tsesis, and also the people of the audience. Okay, the first speaker will be Helen Norton with the paper Manipulation and the First Amendment. It's your turn.
Thanks so much, Oscar. It's really a great pleasure to get the chance to listen to and learn from all of you today and to share some of my ideas as well. I'm going to be talking about the First Amendment implications of the government's regulation of manipulation, especially but not only online manipulation. And I will be focusing on the First Amendment here. But let me start by explaining how I'm using this term manipulation. Thinkers have long struggled to define this concept, and today I'm drawing from very thoughtful recent work co-authored by ethicists Daniel Susser, Beta Ressler, and Helen Nissenbaum. And they describe manipulation as imposing a hidden or covert influence on another person's decision-making. This means influencing somebody's beliefs, their desires, their emotions, their habits, or their behaviors without their conscious awareness. And more specifically, the key features of manipulation as they define it, and as I'm going to be using it today, are a speaker's hidden efforts to shape listeners' decision-making that target and exploit those listeners' vulnerabilities. So this means influencing targets in a way that the targets aren't consciously aware of, and in a way that those targets couldn't easily become aware of if they were to try. Now, to help us understand this concept of manipulation, I think it's helpful to talk about how manipulation is distinct from both persuasion on one hand and coercion on the other hand. And as Susser, Ressler, and Nissenbaum explain, persuasion is the forthright appeal to someone's decision-making power. And coercion, again, is blunt and forthright, because you almost always know that you're being coerced. So in other words, both persuasion and coercion are transparent efforts to influence the target. Although to be sure, persuasion is more respectful of the target's autonomy than coercion. But this is the key point. Neither persuasion nor coercion is sneaky. Manipulation, in contrast, is sneaky. Now note that manipulation includes, but is not limited to, lying and other forms of deception. Falsehoods and other forms of deceptive speech involve false or misleading speech about objectively verifiable facts, like the quality or the price or the hazards of goods and services. So deception is a subset of manipulation in that it's a covert effort to influence listeners' decision-making. But manipulation is a broader concept than deception, because manipulation also includes a variety of hidden efforts to influence decision-making that don't involve false beliefs about facts, but instead exploit emotional or cognitive or other vulnerabilities. Now, speakers have always tried to manipulate their listeners. To give you a 20th century example of this sort of manipulation, think of subliminal advertising. But 21st century technologies, like the use of predictive algorithms informed by the collection and the analysis of huge amounts of data, these technologies offer new potential for manipulation that's different in both degree and in kind from more traditional forms of manipulation. And again, Susser, Ressler, and Nissenbaum give us powerful conceptual tools for thinking about these contemporary problems of manipulation. The many 21st century examples of manipulation include platforms' ability to target advertisements, say, to teenagers, at times when the platform's data surveillance of those teenagers' social media posts shows the teenagers to be sad or lonely or otherwise especially vulnerable to buying things they wouldn't normally buy or to paying higher prices than they'd normally be willing to pay. Other examples of 21st century manipulation include the access to the keyboard monitoring data that helps platforms identify when we're tired or maybe intoxicated and thus vulnerable. Or platforms' control over the content of individuals' news feeds in order to steer those individuals to anger or to fear, which are emotional states associated with barriers to careful decision making. So we should be concerned about manipulation because it injures targets' dignity and because it interferes with targets' ability to exercise their own preferences. And we should be concerned also by the fact that manipulation can undermine autonomy not only in commercial contexts but also in self-governance, in political election contexts, in ways that inflict collective as well as individual harm. And these harms, in my view, are sufficiently serious to justify the government's regulatory intervention under certain circumstances. So next I'm going to talk about the First Amendment implications of regulatory interventions to prevent this sort of manipulation. Now I'll start by noting that a number of thoughtful observers think that these sorts of manipulative user interfaces that I've been talking about should better be understood as unprotected conduct rather than speech that's covered by the First Amendment. As we know, the First Amendment doesn't cover, much less protect, every use of language. And once we recognize this, we might understand algorithms as doing things, right? They're a set of instructions to machines rather than saying things. And under this understanding, their deployment should be considered conduct rather than speech for First Amendment purposes. Now that's an important possibility, and I want to recognize it. But for today's purposes, I'll assume that courts may treat the sorts of manipulative online interfaces that I'm talking about here as speech for First Amendment purposes. Challenging constitutional problems are often difficult because they force us to choose between important constitutional values. For example, they force us to choose between liberty and security, or they force us to choose between speech or religion or equality. And along these lines, I think some First Amendment problems are especially difficult because they force us to choose between speakers and listeners' First Amendment interests. And this is the case, for example, when speakers want to tell lies, but their listeners want the truth. Or when listeners want speakers to reveal information that those speakers would prefer to conceal. Or when speakers want to speak to listeners who don't want to be spoken to. Now, bedrock First Amendment law usually privileges speakers' interests over listeners in these conflicts, presuming that listeners can protect themselves from unwelcome or harmful speech simply by walking away, avoidance, or rebuttal, counter speech. But at the same time, First Amendment law sometimes permits the government's intervention where asymmetries of power and information between speakers and listeners not only increase the likelihood and the severity of harm to listeners, but also limit listeners' ability to rely on exit or voice to protect themselves. And in these settings, courts sometimes interpret the First Amendment to permit the government to intervene on listeners' behalf by prohibiting false and misleading speech, sometimes by requiring speakers to stay away from listeners who prefer to alone, sometimes by requiring speakers to make certain accurate disclosures. In short, inequalities of information and power sometimes matter to First Amendment doctrine. And manipulative speech, as I've discussed it today, inherently involves these sorts of inequalities. Those who deploy manipulative online interfaces enjoy informational advantages over their listeners because their ability to collect and aggregate and analyze data about their listeners means that they often know more about listeners' vulnerabilities than the listeners themselves know. I'm going to start with a few minutes on the regulation of manipulation in commercial settings and then move to political settings. So first, recall that the Supreme Court's long-standing commercial speech doctrine turns on what's best for consumers as listeners. So, in a nutshell, under the court's framework, accurate commercial speech about legal activity, so accurate speech about the price or the quality of a good or a service, that's valuable to listeners. And so the government's restriction of that speech triggers court suspicion in the form of heightened scrutiny. On the other hand, the court has held that commercial speech that's false or that's misleading or that's related to illegal activity offers no constitutional value to listeners and is thus unprotected by the First Amendment, and the government is free to regulate it. So in commercial settings, I propose that the court should refine and extend this commercial speech doctrine to add manipulative commercial speech to the commercial speech that it treats as entirely unprotected because it frustrates listeners' interests. And again, this tracks the theoretical justification of the commercial speech doctrine is all about protecting listeners' First Amendment interests. Now, of course, the decision to treat manipulative commercial speech as unprotected by the First Amendment, then that requires us to have a workable principle for identifying speech that is, in fact, impermissibly manipulative. I'll suggest a couple of possibilities. One is to require evidence of the interface's manipulative success. Manipulative online interfaces are the products of conscious design choices, carefully studied and tested by those who deploy and profit from them to maximize their effectiveness in shaping targets' choices without those targets' conscious awareness. But this means that academics and regulators can measure these manipulative effects as well. For example, testing by legal scholars Liguri and Strahilewicz found certain interfaces to double, triple, sometimes even quadruple consumers' acceptance of sellers' offers compared to neutral choice action. And so Liguri and Strahilewicz thus recommend that regulators engage in testing of their own to identify impermissibly manipulative interfaces, design choices that should trigger the government's regulatory interventions because of their measurably stark effects on consumers' decisions. And in this way, algorithmic manipulation actually at times may be easier to identify and measure and thus regulate than that by manipulative humans. A second approach to identifying commercial speech that's sufficiently manipulative to lose First Amendment protection is to target design choices that display the three characteristics of manipulation as defined by Susser, Ressler, and Nissenbaum. Again, hidden efforts that target and exploit users' vulnerabilities. There's lots more work to be done in defining each of these three characteristics more precisely, but for now I'll suggest hidden to mean not apparent to the user. I'll suggest target to mean identifying specific users with certain vulnerabilities, and I'll suggest exploit to mean deliberately deploying knowledge of those vulnerabilities where there's reason to believe it will shape users' choices to the speaker's advantage. In other words, we can understand speakers' choice to display designs with features that display these three characteristics as a proxy for those choices' tendency to manipulate and thus harm those listeners. Finally, I'll turn from commercial settings to manipulation in political settings. Now, for sure, speakers' efforts to manipulate listeners' decisions about voting and other core political activity occurs in public discourse, which is an area where American court suspicion of government's regulatory interventions is considerably greater than in the commercial context. Under the Supreme Court's longstanding First Amendment doctrine, the government's content-neutral regulation of speech, in other words, its regulation of time, place, or manage of speech rather than its content, this triggers a form of intermediate scrutiny, while the government's content-based regulation triggers strict scrutiny. But either way, the challenge is to cabin the government's considerable potential for overreach through appropriately tailored regulation. So to this end, I'll suggest that the government can tailor its intervention through its choice of regulatory target, in other words, what it targets for regulation, or through its choice of regulatory tool, In other words, how it regulates that target, or both. So as I discussed, in terms of choosing targets, regulators could target interfaces with certain manipulative effects, certain manipulative features, or both. And technology scholar Julie Cohen, for example, has identified particularly manipulative features in public discourse in the political setting to include predictive profiling and micro-targeting, to include design that elicits automatic precognitive responses, and design through the use of algorithms that amplifies patterns of cascading and socially networked spread. So if we move from what to regulate to the question of how to regulate, thoughtful commentators have identified a wide range of possibilities that I can only begin to sketch in our time today. Kyle Langbart, for instance, has described a variety of friction-creating restrictions. These include restrictions on infinite scrolls that unceasingly feed users with new posts, restrictions on autoplay features that manipulate users into remaining online for longer periods of time, during which time the users spend more money and shed more data about themselves, and restrictions that limit or delay users' ability to mass forward and thus amplify content. And another example, Ian Kerr suggests that we should require the strictest privacy settings automatically to apply once a customer acquires a new product or service, such that users need make no manual change to their privacy settings to protect themselves from the data collection that informs their manipulation. Again, those are just a few of many possibilities. I'll wrap things up. Now, for sure, some may fear the government's restriction of manipulation as unacceptably paternalistic. But paternalism describes interference with autonomous choices that the government thinks unwise, rather than interference with practices that themselves frustrate autonomous choice. Precisely because the targets of manipulation are unaware of the ways in which online actors are gathering, aggregating, and exploiting their data, influence their decision-making, online manipulation occurs in a setting that defies the traditional First Amendment model of fully informed, rational actors freely choosing among available options. So in other words, nobody chooses to be manipulated because by definition, targets are unaware of their manipulation and thus can't exercise their autonomy. Intervention here, I think, serves rather than frustrates autonomy. Now, others may worry that it's foolish to try to regulate manipulation because it's long-standing, because humans have been manipulating each other for as long as there have been humans. But that's also true of violence. It's also true of discrimination. That's also true of lying. And yet, sometimes government prohibits each of those behaviors precisely because of the harms they inflict. So rather than ask whether we should ever regulate these all too human behaviors, I think the better question is to ask when, why, and how to regulate them. And that's been the focus of my discussion today. I'm grateful for your time and attention, and I look forward to our conversation.
Okay, thank you very much. Very interesting speech. Now the second speech will be by Filimon Peonidis, and the paper has the title Fake News and Free Speech Theory. This is your turn.
Thank you, Oscar. Let me try to use this share screen. Facility if it is possible, but
yes,
I don't think I don't think that it works. So I have uploaded this PowerPoint, and you can. Okay, I think it works. Okay, thank you very much.
I have shared the. Yeah.
Thank you very much, Oscar. Okay, I decided to narrow down the topic because fake news and its regulation is a very huge topic. And I think we have to decide from which angle we have to approach this issue. And my decision is that we should approach fake news as lies. So this idea, seeing fake news as lies, helps a lot, and especially it helps their moral and legal evaluation. So this is a description of what the producer of fake news does when this person lies to her target audience. So there are three things this person does. First, she presents as news a statement or a set of statements she knows to be false. This means that she perfunctorily follows all the standard conventions concerning the presentation and circulation of news by mainstream media. Moreover, she is epistemically justified in believing that her statement is fabricated. Second, she intends her statements to be believed by a target audience. Her intention to deceive becomes manifest by the fact that she does not give any indication that her statements might not be true. For instance, she does not state that it is based on unconfirmed reports or allegations. She does not make clear that she is being ironic, metaphorical, or making a joke, and she does not rush to retract it immediately after its publication to prevent confusion and misinformation. Third, she realizes that her statement is likely to be believed by at least a subset of her target audience. This belief is essential for distinguishing fake news from nonsense or bullshit that are so obvious that no average person will believe them. Having this in mind, we can say now that fake news is morally reprehensible, as most lies are, although one could think of cases where a person is morally justified to publish fake news. For example, when someone acts under duress. For instance, suppose that a reporter is threatened, is blackmailed by some shady characters who threaten to harm his or her family, and this person deliberately publishes fake news in order to avoid a greater harm. I think that most people would agree that this person is morally justified in publishing fake news. Okay, but enough with moral evaluation. Let's move to a more slippery and difficult field, which is legal evaluation. When we move from moral approach to legal regulation, we are presented with a serious issue. Suppression of fake news means suppression of speech, which is something in principle prohibited or disparates with most liberal legal and constitutional traditions. Thus, a different type of quest becomes necessary, one that would inquire whether free speech considerations allow or disallow the regulation of fake news. So now we have to discuss the regulation of fake news in the light of free speech considerations. I will defend the following regulatory proposal. There are good prima facie reasons which are supported by mainstream free speech theory considerations to withhold constitutional protections from fake news with political content published during the pre-election period. So I would like to focus on a special category of fake news with political content which are published during the pre-election period. Let me define a couple of terms of this proposal. I'll start with pre-election period. The length of the pre-election period, which covers the last phase of public debate and campaigning of parties or candidates immediately preceding elections and referenda, depends on the customs of the land. Yet, the term should be generally construed to include the period between the election day and the inauguration of the new government or the president-elect, which signals the return to normality. Another term that needs some explanation is the term mainstream free speech theory considerations. So this term refers to specific positions taken from the huge bulk of theories, court rulings, arguments, and assumptions developed during the last 100 years mostly by American judges, constitutional lawyers, and philosophers, in their effort to interpret and lay the foundations of the famous provision that Congress shall make no law abridging the freedom of speech or press contained in the First Amendment of the United States Constitution. Why should we focus on this particular type of fake news? I think that the reason is that this type of fake news has severe consequences for the body politic and the proper functioning of democracy, and is not fully covered by existing legal provisions such as those concerning defamation. In addition, empirical research has shown that fake political news diffuses fast and reaches a wide audience. Now, I would like to refer to two examples I'm going to use. These examples I have in mind when I'm talking about fake news. These examples are fictional, but they are inspired by true events, as you can see. The first example, last-minute update. The Bishop of Sin City asked the vicars of all the parishes under his jurisdiction to urge churchgoers to vote for the Yellow Party. Example 2, last-minute update in Sin City. Local officials responsible for the counting of votes were apprehended while trying to dispose of 10,000 valid ballots cast for the Yellow Party. Despite some views to the contrary, the legal regulation of political fake news during the pre-election period is content-based. Thus, they are subject to strict scrutiny, which means that the government should have a compelling interest to suppress them, such as the prevention of illegally cognizable harm. United States courts have ruled that lies in general, a few exceptions notwithstanding, do not constitute legally cognizable harms and therefore should enjoy constitutional protection. In my view, this protection should not apply to political fake news public during the pre-election period for the following reasons. First, fake news can compel citizens to make decisions which they would not have made if they knew the falsehoods and the disinformation contained in them. Second, political fake news not only misleads and disorientates citizens concerning their voting decisions, but it's also likely to incite them when tensions run high to resort to violence and commit unlawful acts. Third, the problem with political news is not only, as a scholar points out, that people will believe the wrong things, but that they will fail to believe the right things. If it becomes common knowledge that lies, in the sense that interests us here, abound during the election period, citizens might not know whom to trust. So in that case, they may trust only themselves, they may stick to their guns, to their views, and I think this opens the road to bigotry. In short, this category of fake undermines the integrity of the democratic electoral process and encourages attitudes that are harmful to the healthy political culture that supports democratic elections, campaigns, and referenda, and keeps them on the right track. It is reasonable to assume that the erosion of the integrity of the electoral process is a legally cognizable harm. There are relevant provisions in many legal systems. In the paper, I refer to a decision from the 20s and the 30s, decisions from the 20s and the 30s of the United States Supreme Court. Okay, but this might be open to discussion. But I think that a clear example is Article 52 of the Greek Constitution, which rules the free and unfalsified expression of the popular will as an expression of popular sovereignty shall be guaranteed by all state officers, who shall be obliged to ensure such under all circumstances. Criminal sanctions for violation of this provision shall be specified by law. Two final considerations. The first thing one can ask is this proposal consistent with contemporary theories that justify free speech as necessary for safeguarding and promoting democratic values. I'll refer only to two theories, an older one by Michael John and a more recent one by Post. Michael John's theory, as it is expressed in his classical Political Freedom, the Constitutional Powers of the People, a book published in the early 60s, a book that focuses on self-government and maintain that free speech is important to make voters as wise as possible, seems compatible with the above regulation. One cannot think how citizens could be made more wise during the election period if they believe lies and act, decide, make political decisions according to lies. However, Post has a different view. Post's theory, expressed in his book Democracy, Expertise, Academic Freedom, First Amendment Jurisprudence for the Modern States, a book published in 2012. In this book, Post professes that the historian is entitled to say whatever she likes to contribute to the formation of the public opinion, and he actually says that even lies are allowed to be said. Of course, one can wonder what kind of public opinion is that if it has been formed through lies, but this is not the line of criticism I would like to follow. On the contrary, I believe that on closer examination, it turns out that Post is preoccupied with certain objections against the regulation of political lies deriving from free speech theory. This objection should be taken seriously. The first objection is that the regulation of mendacious political speech will have a chilling effect on valuable political speech. I don't see that. I mean, if journalists are more careful, if they are checking their sources, if they say that they are not certain about what they're writing, if they warn their audience, if they are ready to acknowledge their mistakes, I think all these things will lead to more responsible journalism, and they cannot discourage valuable political speech. And the only persons that are discouraged are liars and manipulators, but I think this is a good thing. Second, the regulation of mendacious political speech is unnecessary because the only remedy is for more speech and not legal action. I think that it's a very optimistic view to believe that all citizens try to examine thoroughly their sources of information. And of course, people do not act as members of philosophy seminars who are ready to raise tens of scores of objections to a speaker and somehow say that, dispute or challenge whatever a speaker says. This is not the case with ordinary citizens. Ordinary citizens sometimes believe that, or most of the time, believe what they like to believe. And this is a problem. I'm not against more speech, but I don't think that more speech is the remedy. We have to think of some kind of regulation. Third objection, by allowing the regulation of mendacious political speech, we give government an unfair advantage over the opposition. I think there is a point here. Governments can be sources of fake news, I think there must be an independent authority who could check about fake news and then provide the relevant information to courts. All these are open to discussion. In conclusion, I believe that these objections are not decisive and they can be adequately answered, but still the conclusion concerning the regulation of fake political news published during the election period is a tentative one. That's why I spoke about prima facie reasons. We don't have reasons, all things considered. Many considerations should be taken into account, and the final decision would not be an easy one, but I think that this is the road leading to some kind of regulation is a road worth taking. Thank you very much for your attention.
Thank you very much. Also a very interesting approach to fake news and misinformation. I hope we will have time for the debate. Now it's time for Migle Laukyte and her paper, Artificial Intelligence and Hate Speech. Is your turn?
Yes, can you hear me?
Yes.
Okay, great. And I will now try to put my PowerPoint. Okay. Can you see it?
Yes.
Yeah. Okay, good. So hello everybody again, and I also wanted to thank Pérez de la Fuente for inviting me. Well, he's often puts me in front of the topics that I'm not always feel confident, and it's always a great challenge to do something well related to my research, but slightly different at the same time. So today I'm going to talk about the artificial intelligence and hate speech. I will adopt, let me see whether it works. Yes, it works. So yes, I will speak about hate speech from three perspectives. I see that, well, the slides somehow have a problem, but well, when I was drafting them, they didn't have it. So I'm sorry if you cannot read them correctly. So my point here is that, well, I will speak about three ways in which artificial intelligence has to do something with hate speech. So two scenarios are real, and one is like future hypothesis of what might happen. So I start to talk about artificial intelligence as means to fight hate speech that is actually so widely spread online. And I move on to the other side of the barricade, so to say. I will talk about those cases when the artificial intelligence has been used to produce deep fakes, right? The videos that make us believe things that are not true. And then I will address a hypothetical possibility related to the future, and related to the idea that probably or however we want to put it, we're going to deal with a new social group, transhumanists, who might constitute a new social group for hatred. And basically, this transhumanism movement is supported by, but not only, artificial intelligence and related technologies. So I'm going to put on the table the idea that, well, we're going to have a new social group to hate. So basically my idea is that, well, there are a lot of things that we speak about the artificial intelligence, we speak about the technologies, but when we come to the end of the day, it's always about us human, about how we use technologies, how we understand technologies, how we build technologies. And I think, well, artificial intelligence in this sense gives us a lot of room to think about what we're really doing and what kind of society are we heading towards. Okay, so let me see whether it works. Okay, so a little bit again about the concepts here that I'm using. So artificial intelligence here is understood in line with the European Union's concept of artificial intelligence. So it's artificial intelligence are all those systems that show some certain extent intelligent behavior, analyze, perceive their environments. They are action-oriented and exhibit some certain level of autonomy. We're no longer expecting a humankind intelligence and humankind autonomy, but some sort of autonomy is present. And then we also distinguish between artificial intelligence in its virtual form, so virtual assistants, all those programs used for speech and face recognition analysis and like. And then we're speaking also about physical machines, so the robots, autonomous cars, Internet of Things, and all those things that actually where artificial intelligence is embedded. Okay, so first I'll start with the use of artificial intelligence algorithms and other systems in the fight against the hate speech online. So basically the main problem there, as far as to my knowledge, is that we still, that's really great, but we still haven't got it very clear what hate speech is. And I think in many, just listening to the other, to Helen and to Filimon, I was thinking that, well, it's we're here basically confronting two systems of understanding what hate speech is and what the human rights are and what we consider to be protectable, right? Because, well, we see that what we understand as hate speech, unacceptable, illegal hate speech in Europe is very different from what it is in the United States, right? And we actually we're still struggling to understand what the really hate speech is and how to explain it to the machines, right? Because, well, when we speak about the artificial intelligence in this sense, we speak about the algorithms, and those algorithms need to be trained, right? They need to understand what the hate speech is. But if we ourselves still have such a huge problem to understand what it is very complicated to explain that to the machines. So basically we're navigating among insults, prejudice, stereotyping, gossiping, all those things on the slide, and we still have it very difficult to figure out when the hate speech is, well, is too much, is illegal, or when it is still somehow acceptable. And of course, there are also the context and who is speaking. So there are many things in there that, well, makes a hate speech a really complicated phenomenon to understand for the machines. We have this public initiative in Spain. Well, it is the European Union's project that is trying to help the police to identify hate speech on Twitter and Facebook. So basically, it is based on the supervised machine learning. So the human being is always present. The human being is basically labeling the tweets that the algorithm is fed with, so that the algorithm could learn what is the hate speech. However, and I didn't put it in my paper and in these slides, the basic point of this project is also not so much to identify who is speaking, but to identify against whom say certain hate speech is directed, so as to warn the police that, well, in Madrid, in this neighborhood, in this street, there are people who are speaking about, for example, that live in this street, and they're sort of organizing themselves to make justice or to make order, right? So it is also a way to warn the police about what might turn into actual physical aggression. However, for the purposes of of my presentation, the point here is that it is still a supervised machine learning, so the human being is very present, and it is a public initiative, a research project financed by the European Union, where Spain is also participating. But of course, the ones who have most power in changing something are the companies themselves, right? The social networks, basically. So they have the most sophisticated technology, resources, means to use it for that purpose. And actually, they do argue that, well, they are algorithms to identify hate speech or adopt a holistic approach. They can not only understand different languages, they can also understand the images, the contexts, put everything together, and identify that, well, this is the real case of something that is not permissible on the social network. And many of these algorithms are based on the unsupervised machine learning. So the algorithms are learning without any human involvement what hate speech is and what kind of forms it can take. However, what matters for us here is also to understand how important human supervision is. When we speak about the algorithms, we always speak, well, supervised and supervised machine learning. So, but we actually somehow, by using this sort of language, we eliminate the human being from the conversation. But the human supervision matters, and we still want the human to be in the loop, usually, at least in the European Union, and this is the position that the European Commission is adopting. So we want to keep the human in the loop. So it is true on the one hand that, well, human beings fail. We all failed. We have agreed a long time ago that it is a human feature to fail and make errors. And actually here you see an example about the Google algorithm that was trained to consider toxic, to consider hate speech, those tweets that were written in African American vernacular English rather than in, so to say, again, quote unquote normal white American English, how you want to call it. But it's also true that the research showed that algorithms do not need humans to develop bias because, well, the experiment with the multi-agent system showed that the agents, well, the computational entities themselves, like naturally somehow, prefer to interact with similar agents simply because it is, well, easier to interact with something, with an entity or someone who is similar to you. So basically this research was showing that a certain discrimination is inherent in our social interactions, and we will not be able to eliminate it completely. So of course the distance between discrimination and hatred is quite a big one, but well, it already shows that it's not that human fail someplace. It is simply something that is well inherent even in a computational model. So, well, from this perspective, we see that the hate speech is not only a technical problem, but it's also a multi-layered concept that still, well, needs human collaboration. I'm, well, taking too much time, not yet. So my second point was to look at artificial intelligence as a tool to support hate speech. So it is about the deepfakes, very much related to Filimon's fake news, and also to Helen's idea of the discourse of the manipulation as well. So, well, we all know what the deepfakes are. The European Commission has just proposed, has just related deepfakes with artificial intelligence, and well, propose also a mandatory disclosure requirement. And this new regulation would not cover shallow fakes, so those fakes of really low quality when it's obvious that the videos are fake, and well, selectively edited videos by humans. And I also put there the fact that, for instance, all those acts that were proposed in the United States to address deepfakes, they were not so artificial intelligence related, whereas in Europe we somehow decided that the ones we want to regulate are those built by artificial intelligence systems. So, well, the problems with the deepfakes are pretty much clear. I think Helen also, when she spoke about the manipulation, we could have, I could have used what she was speaking about also about the deepfakes. Well, they undermine our capacities. They are, and in case of hate speech, especially what strikes me as very important is the use of well, the social group that is attacked is being used as a weapon against that social group. So I think that is a huge huge problem. Well, so what I wanted to underline here also is that, well, we're somehow both on the one hand using artificial intelligence to produce hate speech, and we also need artificial intelligence to identify the hate speech and, well, to look after, to eliminate, to delete this hate speech, right? So we're somehow, well, making us very much dependent on the artificial intelligence, and, well, it's a huge question whether it is a good thing or not. And again, the third part, now I'm going quicker, relates to the artificial intelligence as part of the transhumanism idea. So the idea that, well, there is a part of the society that says, well, we should use all the available information, communication technologies, biotechnologies, neurotechnologies, whatever, genetics, drugs, whatever, to improve us, right, to enhance us, because it is our duty, because, well, we have all these possibilities, we have to use them, right? So in case of artificial intelligence, we are talking about, well, today we're talking already that the smartphone is taking us towards a new idea of a human, because, well, we already have illnesses that that are caused by the lack of cell phone, right? And tomorrow, the artificial intelligence could be used to connect the human brain to the different objects and the internet. So the idea is that, well, it is not something too futuristic, so much so that we're already speaking about objects of hate speech, animals as objects of hate speech. And, well, that was that was basically my question, is that, well, I have put it in my paper as well, that, well, this emergence of new social group could help us also to understand more about ourselves and more about the hatred, more about the hierarchies of political influence, because, well, we have to admit that we are still focusing on several groups of targets of hatred, but not generally. So gays, lesbians, homosexuals are much more important in terms of hate speech rather than overweight people, because they are less politically important, so to say. And also, there are further questions about the human enhancement, whether these technologies could be used. Whether there is a moral obligation for us, or could be a moral obligation for us, to treat our feelings of hatred, because, well, they seem to be so inherent in our nature. And also, in terms of the algorithms, is, well, see how it's not only about us building them, but it's also about them making us believe things that are not necessarily true. And, well, that is it. I'm sorry if I took too long.
Okay, thank you very much. Yeah, new topics about AI and hate speech, and, well, things for thinking, the different issues for thinking. And now is the turn of Irene Spigno with the paper Gender-Based Hate Speech Against Women, a Comparative Perspective. Irene?
Yes, thank you so much. Thank you so much, Oscar. And let me just put my presentation on. I don't know if you can see it. Yes, I think yes.
Yes.
Well, first of all, well, good morning or good afternoon, depending on which part of the world you are based in. And it's a real pleasure for me to participate in this in this very interesting session on distinct topics and features of hate speech. Thank you so much, Professor Oscar Pérez de la Fuente, for the organization and the invitation to participate in this event. In this presentation, I will concentrate on three main points. First of all, the problem of gender-based hate speech, underlying in particular the lack of specific regulation. Secondly, I will share very few existing experience on gender-based hate speech, a normative one referring to the standards developed by the Council of Europe, and a jurisprudential one with reference to the German experience, a very recently experience actually. And thirdly, I will deal with the possibility, or will make some consideration about the possibility to extend already provided for racist hate speech to gender-based hate speech. And among all the distinct models that the comparative perspective provide, which one which would be the best model to be applied to this kind of hate speech? First of all, what are we talking about when we talk about the gender-based hate speech? Sexist hate speech is rampant in Europe, and women are disproportionately targeted. Sexist hate speech takes place online, offline, in person, and in all forms of social interaction, at school, in the family, in social circles, in public space, at works, through emails, websites, social networks, and so on and so forth. Although it has taken a new dimension through the internet, the root causes of sexist hate speech preceded technology and are fundamentally linked to the persistent unequal power between women and men. And this kind of hate speech takes many forms, both online and offline, in particular with victim reporting and the re-victimization. But also it takes the form of brutal and sexualized threat of death, rape and violence, offensive comments about appearance, sexuality, sexual orientation, or gender roles, but also false compliments, supposed jokes, using humor to humiliate and ridicule the target and the woman in this case. So I think that we could consider this kind of hate speech as a form of violence against women and girls that perpetuates and exacerbates gender inequality. There are multiple factors that contribute to this, to the spread of this hate speech, including the prevalence of patriarchal societies, the spread of degrading messages about women or girls, violent and hypersexualized images, especially in the media, and expectation, social expectation, cultural expectation about the sexuality and the roles that women and girls played in society. And there is another important feature. I don't know what happened with the presentation that was thrown away. I think we are back again. And there is the lack of awareness, the unwillingness among the general public, authorities, and the private stakeholder to take into consideration to address this problem. There are huge gaps in legislation and policy and problems with their implementation, particularly as regards new media, as well online anonymity, but also contribute, this panorama also contribute to a climate of impunity for abusers. Also, sexist hate speech is often treated as a harmless and not serious topic, and women are explicitly or implicitly told to put up with it. However, sexist hate speech or gender-based hate speech not only undermines the freedom of expression of women and girls, but its psychological, emotional, and also physical impacts are real and serious and should be taken into consideration. And as often happens with hate speech, also gender-based hate speech tries to hide behind the fundamental human rights of freedom of expression, and increasing accessibility of the internet has made it easier for users to share their thought publicly, in a public way, but also instantly and anonymously. Freedom of expression is enshrined in several legal binding human rights instruments, but it's not absolute. We all know that, because it is closely linked to other rights. Like freedom of expression, equality between women and men is an integral part of fundamental rights and of any true and real democracy. And what does law do in this with regard to gender-based hate speech? Law is almost silent. There are a lot of works that have been done on racist hate speech in terms of normative, doctrine, but also jurisprudence, especially in light of the Holocaust and the Second World War, especially in Europe. However, hate speech of a sexist type still remains largely unexplored by law. It's not surprising, actually, because one of the sectors in which there has been a lot of discrimination against women, although it sounds somewhat paradoxical, is justice, is the law, which traditionally it is characterized by a strong androcentrism. Consider the application of a discriminatory provision, for example, those in the area of adultery, crimes against honor, or the very numerous cases in which the victim of a violation of human rights is a woman and the judge does not take into account this perspective. So there is in law, in the justice system, still a very strong discrimination against women, and maybe this is one of the reasons why gender-based hate speech are not have not been taken into consideration by law. There is another point that I deal with in the written paper, and it is about if we should consider gender-based hate speech as a form of hate speech. I think that yes, it's a form of hate speech, but I deal with this definition of hate speech and the application to the definition of racial hate speech, also to sexist hate speech in the paper, and I remit to it. Now, I would like to concentrate on the second point of this presentation that is focused on the Council of Europe standards and the German experience. Even if the problem of gender-based hate speech has not been deeply explored yet, it is possible to find very few comparative experience. First of all, the standard developed by the Council of Europe. We all know that freedom of expression is recognized by Article 10 of the European Convention on Human Rights. The exercise of this right carries with duties and responsibilities, and may be subject to restrictions, including in particular the protection of the reputation of rights of others. We have a series of important documents, starting from the recommendation of the Committee of Ministers to Member States on preventing and combating sexism. This recommendation asks states of the Council of Europe to engage in the fight against sexism in all its aspects, make sexist hate speech a crime, and there are adequate remedies for victims of sexist behavior. Also, the Istanbul Convention, the Convention to Prevent and Combat Violence against Women and Domestic Violence. This is the most comprehensive and legally binding treaty that addresses the root that causes the violence against women and calls for greater equality between men and women. And in particular, Articles 34 and 40 of the Istanbul Convention require state parties to criminalize forms of violence related to sex hate speech, in particular, stalking and sexual harassment. And then we have other specific documents, the recommendation on gender equality and the media, the recommendation on the protection of journalism and the safety of journalists and the other media actors. They all deal with the gender-based hate speech in specific sector as media or journalism. Also the recommendation of the European Commission against racism and intolerance on the fight against hate speech, with a specific attention dedicated to gender-based hate speech, and also the internet governance strategies of the Council of Europe and the rights of the child. There is a very interesting case that has been issued recently by a German appeal court. This is one of the very few national experience that we can find. A German appeal court in Cologne ruled last year. It's a decision issued in June 2020, and according to this decision, post-war German laws against hate speech that have been approved as with a reference to racial hate speech and also to Holocaust denial, that also provides provision as far as incitement to the public. According to the judge, this provision also protects women from general insults, because the ratio of this provision is to defend human dignity. In this specific case, the prosecutors had requested the ruling, sending the case for a retrial before the Bonn High Court, but within another of its chamber. And the accused was a man who had a website, and in this website he repeatedly wrote sentences like addressing to women as second-class people, closer to animals, or women as inferior human beings. In the first instance, this guy received just a fine, but what was later acquitted in an appeal court in Bonn. In this second instance, the judges argued that Article 130 of the German Penal Code that prohibits hate speech protects minorities, but not women, that we all know that we cannot be considered as a minority. So the word minority, the word women, sorry, was omitted in the paragraph. So there was a formal argument for this judge to not extend the protection provided by this disposition also to women. But the higher regional court in Cologne said that the paragraph reference to sectors of the population may be applied to women in terms of the law objective of preventing discrimination and its interpretation throughout history. According to the German judge, the sector of the population included in the scope of protection is in no way limited by the expressly mentioned characteristic as minorities, and in addition, the application of the law can hardly depend on coincidences of possibly changing minorities, and this judge considered the word minority as including also other vulnerable groups that are not minorities. So we have this first decision in which the German judge extend the provisions provided for racial hate speech also to gender-based hate speech. So how can we regulate gender-based hate speech? Can we extend to sexist type hate speech the definitions and the regulation that have been elaborated with reference to racist hate speech? The comparative panorama of racist hate speech offers us different regulatory models that could be also extended to gender-based hate speech. I have identified 4 models in a previous research. The first one is the model of freedom, that is the First Amendment model that was already explained by my colleagues, in which this model is characterized by the application of the clear and present danger principle, according to which freedom of expression is limited only with reference to those expressions suitable to be transformed into behaviors by virtue of the specific circumstances of the concrete case. And this expression, they must be to determine a clear and imminent danger to the protected values. So Russia, hate speech, or Holocaust denier are not protected in this model, and freedom of the First Amendment prevails. It's a model born and developed in the Supreme Court of the United States of America, but it was also extended to other countries as Israel or Argentina, for example. We have another model, the model of defense. This is the militant democracy concept, in which the role of a protagonist is played by the human dignity, which allows limiting all those expressions that, by virtue of the content of the message, they transmit, they constitute a direct attack against the human dignity, and consequently against the constitutional order. So this model, this kind of protection of human dignity in the democratic system, implies a militancy, also ideological, of the state. It's like the German model, the Italian one, the Austrian one, also the model of, established by the European Court of Human Rights. Then we have another model, the third one, the no discrimination model, that is the prevalent in international law, but also in Latin American countries. And this model is characterized by the exclusion from the area of protection of freedom of expression of all expressions, switchable behaviors, both due to its content and the circumstances. They exclude all expressions that are able to generate a discriminatory context. And finally, the model of multiculturalism. This is the model that was born, if we can say this, you can use this expression, in Canada. In this model, the protected value is constituted by harmony and peaceful coexistence between the different groups. Consequently, all those expressive behaviors suitable to endanger this good are punished. As I was saying, this model was born in Canada. Canada generated one of the most comprehensive, instructive, and attractive systems at the normative and jurisprudential level. And in this model, freedom of expression can be limited only in the cases of the most intentionally extreme form of expression, and only when values such as dignity and equality are put at risk, considered especially with reference to minority and vulnerable groups. So, and this is the question, the final question to end this presentation. Which of this model of regulation would work better for gender-based hate speech? The point is that I don't have an answer to this question. I can just give some consideration. I strongly believe, of course, that gender-based hate speech is a critical form of hate speech, and it should be treated as such. We can discuss of which model of regulation it could be better to apply to this form of hate speech, if a more restrictive one based on penal sanction, on a militancy, or a more tolerant one, which bet on the combination of penal sanction and the education to respect and the tolerance. In this model, for example, I think that the model of multiculturalism pushes more than the other three models toward the rejection of hatred, not only through criminal sanction that, of course, in extreme cases are very important and fundamental, but rather through education for a culture of tolerance and respect. Although it is clear that a certain manifestation of hatred must be punished, in reality, the models that only foresee this sanction could not be adequate and sufficient. To inflict a punishment by imposing a sanction such as a fine or a deprivation of personal freedom does not always imply a transformation of the hate message and a solution to the main problem. If the Holocaust and Auschwitz were built with words and not with bricks, as a rabbi said, also the silent and invisible genocide that is killing women all around the world is because they are women, for gender reason, because they are women, is built with the sexist words. So we have to find a way to stop it. I will leave the presentation here. Thank you so much for your attention, and I hope we have some time for the discussion on this very interesting topic. Thank you so much.
Thank you very much. It was also an interesting approach to the other model, to the German model, not the American, but also with points from the American. Okay, now it's time for discussion. Today, the discussant or moderator in the American terminology will be Alexander Tsesis, and now is the turn of Alexander Tsesis for the questions.
Thank you so much, first of all, Oscar, for doing the bulk of the work in organizing. I'm deeply grateful to you. We have only a little bit of time, so I'm going to try. I know Helen needs to get off at 1:30. Right? Am I right, Helen?
Yes, thank you.
Yes, thank you. And then I need to be off around that time as well. But these were fascinating papers. I'm going to try to be quick, which really there's so much to say on all of them. I really enjoyed reading them, and I must say that I sympathize with the views in all of them, and yet I find a disconcerting pattern of lack of specificity that riddles this generally, the regulation of false speech that the Supreme Court has pointed out in cases like Alvarez and Snyder v. Phelps, a case that people didn't discuss, but I think was discussed at least in Helen's paper dealing with attacks against a particular group, but it also had to do with falsification. So let me go through these papers one by one, but then also to try to leave time, which I don't know how exactly we're going to do in 10 minutes, but I'll try. So I wonder, Helen, whether the term that's used by Susser and Rosler and Nissenbaum, manipulation, is just too ambiguous for First Amendment purposes. It works in their article, but I question whether it's sustainable under First Amendment and content regulation. So, for example, they give 3 characteristics to identify manipulation based on the user's or the target's vulnerability. But I wonder whether that's particularly helpful outside of physical type of reports, right? Because exploiting vulnerability, I mean, people exploit vulnerability in all sorts of ways. Businesses do it, private individuals do it. We do it when it comes to trying to get ahead in jobs. We do it when it comes to trying to sell some sort of product and to find a vulnerability in a company, so that I don't know how that could be made actionable. I was surprised at the degree to which you were willing to countenance regulations. You say that the existential democratic threats posed to by today's manipulative online practices thus may now outweigh traditional dangers of governmental regulations of speech. It's interesting that you use outweigh, which is clearly a balancing program where the Supreme Court of the United States is not headed in that direction, but is using, as you know, much more formalistic categories there. And I also looked at this, I also was surprised that in this paper you write, more specifically, we can and should understand manipulative commercial speech to be entirely unprotected by First Amendment with the government regulations subject only to rational basis scrutiny. And I wonder how that plays out, how that conforms or is consistent with your position, as I had understood it elsewhere, that social media companies enjoy free speech protection. Maybe you've modified your view, or maybe even there you meant a certain limited amount of First Amendment protections, but I don't know if the rational basis scrutiny that you propose, that those two positions are consistent. So let me move on with, and I apologize, I'm going to try to get in questions to everybody before I stop with Filimon. First of all, you mentioned incitement, and I'd be very interested to know what you mean by that term, because of the very different ways that it's used in the United States and Europe. But even with the European model, Europe has been very careful not to, as far as I know, and I've done the research on this, so either I'm missing it or it's an issue for your proposal, that incitement to instigation or incitement to overthrow the government seems to have been done away with in many countries, at least in Great Britain, certainly in the United States, and I think just elsewhere. And the fear is that autocrats can exploit this category in order to overturn democracy. And in fact, that's what Erdogan, Putin, and Xi Jinping arguably have done. That they say that you're making these anti-democratic views. Putin says it, Erdogan says it, but of course it's just their excuse for advancing autocracy. And I wonder what your term significantly harm to democracy means, and whether it's narrow enough to censor a speech. One place where you and Helen, Filimon, where you and Helen overlap is in that commercial speech doctrine should be added to this manipulative. Well, Helen says that the manipulative commercial speech should be added to this category. And I do think that there's an overlap, because Filimon speaks about misleading commercial speech. If I may just put a very quick plug in, I have an article in the Notre Dame Law Review called Marketplace of Ideas, Privacy, and the Digital Audience. Marketplace of Ideas, Privacy, and the Digital Audience, where I make a similar argument, although I think the two of you expand further about the lower level of protection needed for commercial speech. Then turning to Migle, hope I'm pronouncing your name correctly, pardon me if I'm not. I wonder whether some of your proposals are too behavioralist. Shouldn't people learn to internalize anti-discrimination norms rather than acting mechanically on the human brain through therapeutic, pharmacological, and physical interventions? You seem to adopt a very positive perspective, right? We already have therapists and drugs to treat many human features that are not acceptable, such as aggression, violent behavior, and the doubt is whether the means we already have could be improved on to help technological advancements that transhumanists believe so strongly in. Aren't there already transhumans? I mean, there are already people who use parts of their body that require AI, heart monitors, pacemakers, similar devices. Presumably discrimination would be prohibited against those people already. So I wonder what the model would add to what we already would consider to be discrimination against people, let's say, who have disabilities. Irene, I wonder whether the term hostility and resentment are ones. Let me start in a different way. Your model really requires intent. It requires animus. But I wonder, what about hatred, whether towards women or towards other protected groups, that's purely opportunistic? In other words, it's not based on hatred at all. It's an attack against women, gays, blacks, Jews, whomever, but not because of any hatred, but rather because of their vulnerabilities. Shouldn't that too be actionable, irrespective of the fact that there is no intent in those situations, but rather, and the final thing, Irene, I wonder, is whether right now most categories in the United States, differently from Europe, of discrimination are based on roles, positions, such as the workplace, but not against just pure private sexist speech. Wouldn't regulation of pure private sexist speech really expand too far what's actionable under a law? I'm sorry to have taken so long, but your papers were just so thoughtful.
Okay. Well, now it's time for the answers for the same order. Please, Helen.
Yeah, thank you, Alex, for those characteristically thoughtful questions, and thanks to Filimon, Migle, and Irene for really thought-provoking papers. I'm going to have to step off at hour, so Alex, I can't do justice to all of your questions. I'll focus on just one now. You were surprised by the fact that I recommended that we treat manipulative commercial speech as entirely unprotected by the First Amendment, subject only to rational basis scrutiny. Well, that's exactly the current posture of false commercial speech, misleading commercial speech, and commercial speech related to illegal activity. It's entirely unprotected by the First Amendment and subject to the government's regulation that survives rational basis. And when we think about why false, misleading, and illegal commercial speech related to illegal activity is unprotected by the First Amendment, it's because none of that helps listeners. It all frustrates listeners' constitutional interests. And manipulative commercial speech, I believe, shares those characteristics, so we should treat it that way. Then the hard question, of course, and you identified this, is, all right, we got to figure out what manipulative commercial speech is, just as we have to figure out what false and misleading commercial speech is, and commercial speech related to illegal activity, and that can be challenging. But I do think that Susser, Ressler, and Nissenbaum have given us the conceptual tools to measure this and recognize it, and I will continue to think about your very, very good questions. Thank you.
It was wonderful to see you, Helen. I can't wait to see you soon. Bye. Have a great day.
Okay, thank you. Now is a turn for Filimon.
Thank you, Alex. I think that the term incitement, if it is understood as a legal term, might be misleading because there are different conceptions of incitement, and what I have in mind is a philosophical conception expressed by the famous corn dealer example in John Stuart Mill's On Liberty. But I think we can skip this term and instead use the term motivation. My point is simple. I think that certain types of political fake news motivate people in extreme circumstances to commit unlawful acts. And even without saying in expresses verbis that you should do this, or you should do that, you should invade the city hall. So my point is that it's something we can do without it. We don't need this violence, we don't need this fake news, and all this somehow work against the quality of democracy. So it's not a legal point about what incitement is, it's a more general point about how fake news can do damage to the quality and the proper functioning of democracy.
Okay, now it's time for Migle.
Thank you, Oscar. Thank you, Alexander, for your feedback. Well, my point there was that while we distinguish in the transhumanists as people who actually deliberately decide to enhance themselves, right? We're not speaking about the hard pacers. And well, those tools that you have to actually, you don't have a choice whether to put them or not, because either you live or you die, or you're in the difficult situation because of the disability you have. And when it is a choice-based decision to enhance yourself to a level that makes you more competitive on the job market, on your career path, well, it generates a refusal. I believe, right? It generates an acceptance, it generates, well, hatred and hate speech, actually. So we already see it among the sportsmen, right? Among the athletes, and who, well, we have those cases where the, people who earlier would have been considered to be disabled right now compete with, so to say again, normal people, and this also generates certain refusal. So I was referring to those who choose to do something with themselves rather than, well, people who didn't have a choice. and also related it to the fact that, well, when you can choose, well, it means that you have a financial stability, well, financial resources to do that, and whether, well, we are, so to say, introducing a new group for hatred, and how and what this new group would tell us about hatred as such. Thank you very much.
Thank you. Now it's time for Irene.
Thank you, Alexander, for this so interesting feedback. I think, of course, I have been studying hate speech for many years now, and I always face with a very complicated, slippery slope topic. I think that the effect of the hate is very different, depend actually on the level of vulnerability the interested group is as. Of course, it's not absolute. Also, the topic, there are some groups that are more or less vulnerable, depending on the multi-factors. Among the others, the context in which they are based. For example, it's not the same being LGBTI in Finland or LGBTI in African countries or in Asian countries where homosexuality is criminalized, for example. And of course, depending also on the history and of course the role. As far as women are concerned, this is very clear, this is very evident, and also if we connect hate speech with its suitability of generate violence, I think that this topic requires a more attention and a higher attention in most conflictive contexts rather than in less conflictive contexts. And for example, the example of Latin America rather than Europe, where thousands of women are murdered every year, of course, it gives to this issue a different aspect. It needs a urgent attention. Thank you so much for your feedback.
I don't know if Alexander wants to add something.
No, I don't, and I apologize. I have to return off. I have to make a phone call. I was supposed to make a phone call 5 minutes ago. But thank you so much. It was really an honor, and I learned a lot from all of you. And thank you for just stimulating my thoughts. And Oscar, thanks so much for doing this and getting this together in the summer so that we can enjoy each other's company rather than constantly being on our own during the Zoom time. So with that, I'm going to try to sign off here if I can, and hopefully we'll see you all some other time.
Okay, thank you very much. Thank you very much, Alexander. Okay, I don't know if someone in the audience, a brief comment, someone in the audience? Yes, Jack Drech.
First of all, I would like to congratulate to Oscar for organizing such excellent meeting, and for to all speakers for a very interesting presentation. And I have two questions. First to Irene Spigno. I'm sorry if I made a mistake in your pronunciation of your name. Because the question about how to regulate gender-based hate speech, this is a very important question, and we discussed with Oscar a week ago during the session on RC26 IPSA, International Political Science Association, and yeah, from my point of view, I'm interested in your opinion. What is because I think that we should analyze such 3 steps attempts. First step should be education. Second, soft law, and the last step, hard law. Soft law, I mean about self-regulation, of course. Yeah. What is your opinion about such attempts to this issue? And second question is to Migle Laukyte. I'm sorry for pronunciation your name also. And thank you very much, because this is very for me it was very fruitful, because we are going to launch the new project about artificial intelligence and not hate speech. However, I'm sorry, can you hear me? Yeah?
Yeah, we can hear you.
Okay, I'm sorry, because my Wi-Fi is maybe problematic. And fake news. So do you think this is possible because in my opinion the idea of using artificial intelligence to combat with hate speech and fake news, it's a very interesting idea. I don't know it is possible or not. However, maybe next year I will be ready to present the result of this Polish project about artificial intelligence and fake news and combating with fake news. Yeah, because always this question how artificial intelligence is smart. Yeah. And it is possible to engage AI to such task or not. Of course, the majority steps are for IT departments in this project. However, I think it's maybe this is maybe a hopeful idea. I'm interested in your opinion about such possibilities. Thank you very much.
Just a minute. I want to add a final question, and then you answer all, and we close the webinar. My final question is for Filimon. It's about the fake news and misinformation. My question is, do you think is a problem for democracy the searching for an official truth? This could be a problem. I think you have explained all the problems, all the tensions between the First Amendment and this question of the fake news, but I think is a problem that if you ensure an official truth, maybe you are losing something in the debate, and you have to educate people, not prohibit speech. That could be a possibility or something to discuss. Yes, Jack Drech.
Oh, I'm sorry, it was my mistake because I put the button with right hand. However, everything is okay. Thank you very much.
Okay, then, well, I don't know in which order, maybe the order of interventions. Yeah, maybe the first to answer is Filimon.
Okay. Okay, the term official truth has various connotations. Sometimes it refers to a dogma, to an official doctrine, to a religion, to a political theory, to a moral theory. What I'm interested in is factual truth. The idea is, has the police arrested two people trying to meddle with the election? This is a factual truth. Yes or no? So I'm interested in fake news that contain factual truths that can be proved or disproved. I'm not interested in articles about opinions, views, values, approaches. Of course, there is no official truth concerning all these things. But I think that there is something called factual truth, although many people disagree with me. But I'm referring to news that can be proved or disproved through empirical evidence. Otherwise, things might get dangerous, as you said.
Okay, yes, very, very good answer. Migle, is your turn?
Okay, can you hear me?
Yes.
Okay. Okay, so thank you, Jędrek, for your, I'm sorry if I mispronounce it, but although we are neighbors, so Lithuanian and Jędrek is Polish, but still languages differ quite a lot. So as to your question related to artificial intelligence, fake news, yes, I think it is possible to combat fake news with the artificial intelligence, and exactly, and well, so much so that when I was speaking, especially if these fake news are based on deepfakes, because deepfakes many times, like really good deepfakes, the only way to identify, to understand that it's a deepfake is to use artificial intelligence. So if a fake news is based on the deepfake, so we cannot identify it as fake without using technology. So this was my question. That's to say we're become too dependent on artificial intelligence to understand what is going on around us, right? In general, in general, to fight against the fake news, yes, of course. Yes, of course. It is possible, so much so when we're speaking about the fake news that spread throughout the networks, throughout social networks quickly, and you do not have a human ability to, human capacity is insufficient to follow, fight, and stop them and do something about them. So, well, I think it is not only possible, but it is necessary. Although, again, we have already in California, we have this anti-bot act that already prohibits to use bots to that attempt to influence, for example, political elections. So many social networks have identified programs to fight these bots and to make people, to involve citizens to denounce that certain tweets have been produced by bots. So I think, well, again, it is not only possible, but it is necessary because we don't have other means to fight fake news, hate speech on social networks. Thank you for your question.
Okay, and now it's time for the last intervention of Irene Spigno.
Okay, thank you. Don't worry about the pronunciation of my name. If I try to pronounce your, I think that I do a worse work than you do. Well, about the question on how to regulate hate speech, I think that it's necessary an integrated intervention, an integrated solution, because especially in those countries, and it is the most prevalent approach in Europe, where many states, and also this is the approach from the European Union and the Council of Europe, the main approach is to punish this kind of discourse in order to educate somehow, no? I think that it can be work in the short time, but not in the long period, because we have to think about, okay, punish the person responsible of a certain crime, and if hate speech is a crime, it's okay to punish that person for that crime, but we have to change, I think, the cultural context, and we can do this with another type of solution, and this solution is the educational one. Of course, I don't want to say that we have to just make a course to solve the hate speech problem, in this case the gender-based hate speech problem. We have to think about, it's necessary to think about an integrated, multi-disciplinary intervention that include education, soft law, and hard law. The choice of one does not exclude the inclusion of others of these tools. So I think that we have to work on this complex solution.
Okay, thank you very much. Well, it's time to thank all the speakers for this interesting session, also to the audience. And okay, the session will be recorded, and the next session will be on 26th of July. and we'll have new papers to discuss. Thank you very much to everyone. Thank you, Filimon. Thank you, Migle. Thank you, Irene.
Thank you.
Thank you.
Thank you. Thank you, Oscar.